Imagine waking up, grabbing your morning coffee, and checking the news, only to realize that the rules governing the tool you trust to protect your family have fundamentally shifted while you were sleeping. No massive headlines on the mainstream networks, no emergency alerts on your phone. Just a quiet surgical strike on the status quo. Something historic is unfolding right now, and if you're a gun owner in 2026, you can't afford to be the last person to find out. Between November 2024 and January 2026, 47 states either updated their pistol carry statutes, revised their reciprocity agreements, or issued new enforcement guidelines to local law enforcement. That's not a trend, that's a synchronized overhaul. And it didn't happen because politicians suddenly agreed on guns. It happened because three pressure points hit at the exact same time, creating a perfect storm that's rewriting the Second Amendment landscape across all 50 states. For years, the phrase nationwide reciprocity was a ghost, a dream for some, a nightmare for others, but a reality for nobody. But as we sit here today, the gears of the federal government, the Supreme Court, and a wave of emboldened state legislatures have finally locked into place. We aren't just talking about a minor tweak to a hunting permit. We are talking about H.R. 38, the Constitutional Concealed Carry Reciprocity Act, moving through the 119th Congress with a velocity that has left even the most seasoned legal analysts in Washington breathless. The patchwork of confusing state lines is being torn down, and in its place, a new standard is emerging. But with that freedom comes a new set of rules that are catching people off guard. The truth is, nothing exposes a broken system better than what happens to people who thought they were following the law right up until the law turned on them. Take Shainene Allen, a mother from Pennsylvania who made a simple mistake that almost cost her everything. She had a valid Pennsylvania concealed carry permit. She informed a New Jersey police officer during a traffic stop that she had her legally registered firearm in the vehicle, exactly as she'd been taught in her training. She thought she was doing everything right. Instead, she was arrested, faced years in prison, and became a national symbol of everything broken in America's carry law system. Her crime wasn't malice, it wasn't negligence, it was geography. For decades, the American gun owner has lived in a state of legal schizophrenia. You could be a model citizen in Pennsylvania, but the moment you crossed the bridge into New Jersey, you were a felon in waiting. We've seen it happen to traveling nurses who carry for personal protection while moving between assignments in different states. Several have been arrested at state borders, not because their permits were invalid, but because the receiving state didn't recognize them, and the nurse didn't realize the rules had changed. Their careers derailed, their savings drained, their futures shattered over a legal technicality that had nothing to do with safety. Then you have the military families relocating under orders. Service members who hold valid permits from their previous duty station often discover their new state won't recognize that permit and won't issue a new one quickly enough to bridge the gap. They're left unprotected during a move they didn't choose, punished for serving their country. But the data is in, and the political climate has shifted. 24 attorneys general, representing nearly half the United States, have sent a unified message to Congress. The system is broken beyond repair. They aren't just saying it's inconvenient, they're saying it's dangerous for law enforcement and citizens alike. When you have police officers in one state trying to interpret the permit requirements of 49 other states during a high-pressure traffic stop, you aren't creating safety, you're creating a powder keg. Congress finally realized they couldn't ignore the reality of the American traveler anymore. Truckers, families on road trips, and daily commuters have been accidental criminals for too long. If you want to know why this is happening now and not 5 years ago, you have to look at the power players. When President Donald Trump doubled down on his support for nationwide reciprocity, it didn't just energize a base, it fundamentally changed the math in Washington. It turned a fringe idea into a top-tier legislative priority. But it's not just the executive influence. Look at the House Judiciary Committee. Their recent 18-9 vote to move this forward wasn't just a win. It was a landslide in political terms. It sent a shockwave through the Capitol that told everyone, the delay is over. And then there's the Supreme Court. Following the precedent set by Bruin, the courts are no longer asking states for permission to protect the Second Amendment. They are using history and tradition as a scoreboard, and right now, the states that rely on arbitrary bans and confusing rules are losing. After years of permitless carry expanding across red states, the predicted bloodbath never materialized. Crime didn't spike. Permit holders remained statistically safer than most professional groups. And the old argument that stricter carry laws equal safer streets collapsed under the weight of its own contradiction. So states did what governments always do when reality breaks their rules. They adapted, some loudly, some quietly. But all of them moved, and that movement created the new landscape you're standing in right now. The 10 rules we're about to break down represent the most comprehensive shift in pistol law since the modern permitting system was created. These aren't theoretical changes coming someday. They're active right now, reshaping how Americans carry, travel, and defend themselves. And if you're waiting for someone to send you a memo, you've already missed the critical window. The first and most explosive change under this new framework is what I call the wallet growth rule. Under the new 2026 standards, the permit in your wallet is no longer a permission slip with a shrinking radius. It is being transformed into a nationwide credential. If your home state trusts you to carry, every other state that allows concealed carry must respect that trust. Think about the implications. No more pulling over at the state line to lock your firearm in a safe. No more scanning reciprocity maps at a gas station like you're studying for a final exam. This rule crushes the chaos. It treats your right to self-defense the same way the government treats your right to drive a car. But here's the critical detail most people are missing. Starting in 2025, states began adopting a standardized pistol permit format that includes machine-readable elements, expiration dates in a uniform location, and issuing state verification codes that law enforcement can confirm in under 10 seconds. This wipes out the chaos that's been drowning traffic stops for years. Before this shift, an officer pulling over someone from 3 states away had no reliable way to verify that worn-out plastic card was legitimate. Different colors, different layouts, different security features. Some permits looked like library cards from 1987. That confusion created hesitation, and hesitation during a traffic stop breeds bad outcomes for everyone involved. The new format doesn't force every state to issue identical cards, but it does require every permit to speak the same language where it matters: the expiration date, the issuing authority, and the verification pathway. If you live in one of the 29 states that have embraced constitutional carry, you've likely felt like a second-class citizen the moment you hit the state line. You have the right to carry without paperwork at home, but that freedom effectively pauses the second your tires hit a different zip code. The second rule of the 2026 update is the glitch fix. Under H.R. 38, if you are a resident of a state that allows carry without a permit, you are treated as having a valid permit for the purposes of federal reciprocity. This is massive. It acknowledges a simple truth. If your state trusts you enough to carry without a license, other states shouldn't treat you like a felon just because you haven't paid a tax or filled out a form. This rule turns consistency into a shield, ensuring that permitless doesn't mean unprotected when you travel. One of the biggest fears for any traveler is the roadside legal test. You get pulled over for a broken tail light, you inform the officer you're carrying, and suddenly you're in a 45-minute debate about whether your out-of-state permit is recognized. The third rule rips that uncertainty out of the equation and forces a uniform standard that officers must follow, not interpret. If your paperwork is facially valid, the law now states that it is prima facie evidence of your right to carry. Officers can no longer lecture you or claim your permit isn't accepted based on a personal grudge or an outdated memo. But here's the twist that makes this enforceable. More than 40 states have integrated their permit systems into a shared database that updates daily and allows cross-state verification without phone calls, faxes, or guesswork. This is the technological backbone that makes everything else possible. Before this system went live, reciprocity was a patchwork nightmare. One state might recognize 30 others. Another might recognize 12. A third might have agreements that expired years ago but never got updated online. Carriers were left scanning outdated charts on random websites, hoping the information was current. Officers were left trusting a piece of plastic with no way to confirm it in the field. The database solves that. When an officer runs your permit, the system instantly confirms whether your home state issued it, whether it's still active, and whether the state you're currently in recognizes it. No lag, no ambiguity, no relying on a chart printed in 2019. For years, if you were caught in a border trap, the burden of proof was on you. You had to hire a lawyer to prove you were legal. You had to prove your training was sufficient. You had to prove you were a resident. The fourth rule flips that script with extreme force. It establishes that if a prosecutor wants to challenge your right to carry under H.R. 38, they must prove you weren't qualified. They have to prove, beyond a reasonable doubt, that you didn't meet the requirements. This shift shuts down lazy assumptions and bad faith prosecutions that have drained the bank accounts of lawful carriers for years. It signals to every anti-gun jurisdiction: if you want to bring a case, you'd better have more than just a suspicion, because the era of the gun owner having to prove their innocence is over. In response to court pressure and legislative reform, several states that previously required training for permits but never specified what that training had to include have now published exact standards: hours, topics, live fire requirements, instructor qualifications, everything. This matters because vague training mandates were being weaponized. Some jurisdictions would reject out-of-state permits claiming the training wasn't rigorous enough, but they'd never define what rigorous meant. It was a moving target designed to fail. The new transparency rules eliminate that game. If your state requires 8 hours of instruction, including 4 hours of live fire and legal review, other states can now verify that in the database. They can't reject your permit based on a feeling anymore. They need a reason, and that reason has to be documented. This is the rule that changes behavior faster than any speech. In the past, even if you were arrested incorrectly, the financial nightmare fell on you. You'd spend $20,000 on a lawyer to get a mistake cleared up, and the police department would walk away with zero consequences. Not anymore. The fifth rule introduces a private right of action. If law enforcement gets it wrong and arrests a lawful carrier despite H.R. 38's protections, the agency is now on the hook for the fallout. We're talking every court cost, every legal bill, and every dollar spent defending your name. When wrongful arrests start hitting police budgets, the culture shifts. Agencies will start training their officers to respect your rights because they simply can't afford not to. The sixth rule is designed specifically for the truckers, the delivery drivers, and the long-haul commuters. It crushes what I call the vampire trap. Under the old system, your legal status could reset the moment the pavement changed color. This rule ensures your status is locked in transit. If you leave your driveway legal, you stay legal until you reach your destination. It stops states from weaponizing micro-borders, those tiny slivers of land where one city's ordinance contradicts another. It restores something basic, the ability to travel from point A to point B without wondering if the next exit might change your entire future. As H.R. 38 moves through the 119th Congress, one of the most common questions is, does this mean I can carry anywhere, even if a business says no? The seventh rule provides the answer, and it's a masterclass in legal balance. Congress didn't write this bill in a vacuum. They knew that forcing firearms into private homes or businesses would trigger a wave of property rights lawsuits that could kill the bill entirely. So H.R. 38 draws a clean line. Private property owners still hold the right to prohibit or restrict firearms on their premises. However, here's the 2026 twist. The bill stops states from using private property as a backdoor ban. In states like New York, we saw attempts to declare all private property gun-free zones by default. The seventh rule shuts that down. Unless a property is specifically posted or you are personally told, the default state is now freedom, not prohibition. While H.R. 38 is a massive expansion of state-to-state reciprocity, it does not create a Wild West on federal land. The eighth rule serves as the guardrail. It explicitly states that federal gun-free zones, post offices, federal courthouses, and secure government installations remain under federal jurisdiction. What changed isn't the law. What changed is the expectation that carriers know it. Courts were seeing too many cases where someone with a valid state permit genuinely didn't realize federal property operated under separate rules. The outcome was always the same: criminal charges, lost permit, potential felony. Some states now print federal facility warnings directly on the permit card. Others require a signed acknowledgement during the application process. A few have added entire sections to their training courses dedicated to federal versus state authority. This is the rule that has attorneys general in restrictive states losing sleep. The ninth rule is the preemption clause. It states that this federal law supersedes any state or local law that contradicts it. If a city like Chicago or Los Angeles tries to pass a local ordinance saying, "We don't care about H.R. 38, you can't carry here," this rule renders that ordinance legally void. This is the backbone of the entire movement. It destroys the idea that a right can be zonal. For decades, gun owners had to memorize which cities had assault weapon bans or magazine limits that applied to travelers. H.R. 38 forces a uniform federal standard for the act of carrying. The final rule isn't just a modern regulation, it's a revival of American history. To survive the Supreme Court's history and tradition test, H.R. 38 leans on a powerful precedent, the 1887 New Mexico territorial law. Back in the late 1800s, lawmakers recognized that travelers faced unique risks. They explicitly protected the right of people on the move to carry firearms for self-defense. The 10th rule reconnects modern gun law to these roots. It forces states to recognize that self-defense is not tied to a fixed address. It follows the person. By using a law written just decades after the founding, H.R. 38 creates a historical shield that makes it nearly impossible for modern courts to strike down. It proves that nationwide carry isn't a radical new idea. It's a return to form. As we stand here in February 2026, the battle isn't over, it's just entering a new phase. While H.R. 38 has been reported out of the House Judiciary Committee with that decisive 18-9 vote, the blue wall is pushing back. Attorneys general in California and New York are already drafting what they call reciprocity resistance packages. They are trying to find ways to make it so difficult to carry through insurance requirements or sensitive place expansions that even with federal reciprocity, you'd be afraid to step out of your car. But here's what they aren't telling you. The momentum is against them. With Republicans holding the gavel in the 119th Congress and a Supreme Court that has already said the Second Amendment is not a second-class right, these state-level roadblocks are being treated as temporary speed bumps, not permanent stops. The patchwork is dying, the invisible borders are fading, and the accidental criminal is becoming a thing of the past. We are witnessing the most significant shift in firearms law since the founding of this country. The manufacturers are already seeing the writing on the wall. We're seeing a surge in compact and subcompact production because the industry knows that millions of Americans who used to leave their guns at home are now preparing to carry across state lines. Sheriffs in pro-Second Amendment states are already updating their training manuals to ensure their deputies know how to verify out-of-state permits in seconds, not hours. If you're a gun owner, the advantage starts now. Update your training. Verify your permit status. Learn the new reciprocity rules. Download the state-specific apps that track changes in real time. And stop assuming the laws you learned 5 years ago are still accurate because they're not. The legal landscape moves fast, and staying informed isn't optional anymore. It's survival. These 10 rules are your roadmap for 2026, but this only works if you stay ahead of the curve. Don't just watch history happen. Be part of the community that shapes it.